to the Law News Network. I'm your host for this late morning, Caroline Polisi, and we're bringing you a trial testimony, previous testimony in the case of Nevada versus John Valerio. This is the second trial for Mr. Valerio for a crime that was committed 31 years ago, and the trial that took place 29 years ago. Now remember, this is just a second trial for the guilt phase of this sentence, because this is a death penalty case. And we're very fortunate today to have some very special guests, because we're not going live into that courtroom until around 4 p.m. here at LawNewz. We have some time for analysis. So joining us today, we're very excited and happy to have Ron Bamieh here. He's a former prosecutor and now a criminal defense attorney. And Ron has actually worked on death penalty cases, and so it'll be interesting to get some of his insight. Ron, how are you?
Good morning. Thanks for having me.
Thanks for being here with us. So I was wondering if you could, a lot of us here at LawNewz, we are lawyers. However, I myself certainly have never tried a death penalty case or defended a death penalty case. Just to get our viewers up to speed, I know that there are some different procedural elements associated with death penalty cases, like there are two lawyers typically. Could you tell us a little bit about how that works?
Sure. Well, in California, for example, and I think Nevada also, where this case is being had, there are two phases to any death penalty trial. The first is the guilt phase, what we call it. That's where a jury decides whether the person is guilty. You have to be guilty of some form of first-degree murder, and usually something special. In California, we call those special circumstances. A special circumstance could be murder when you lie in wait. It could be murder using a destructive device, a bomb. It could be murder in California as part of a gang from a car, when you shoot from a car. There's a number of special circumstances. Shooting police officers is a special circumstance. Multiple murders is a special circumstance. So to be eligible for a death penalty in California and in Nevada, you must be guilty of first-degree murder plus a circumstance which the legislature has deemed worthy of the death penalty offense. So the way the trial would proceed is you first do the guilt phase, where the person, like any other trial, would be determined whether he was guilty or not guilty of the first-degree murder in the special circumstance. And then if he is found guilty of the murder in the special circumstance, then a penalty phase occurs. Typically, this happens right after the guilt phase. In the cases I've done, usually we take about 2-3 weeks off between the guilt phase and the penalty phase, then come back for the penalty phase. In this case that we're talking about in Nevada, we're doing it. He was convicted in '88, I believe. So you're doing it 30 plus years after the fact, which obviously is extremely unusual.
Right. So how often do you see circuit courts overturning merely one portion, in this case, the sentencing, the punishment phase? Is that typical, or is this highly unusual?
Well, it's not. Well, appeals in general, getting a case overturned on appeal on any criminal case is unusual. Right. They happen in less, I think, than 5% of all cases. So that in itself is unusual. For an appellate court to go back 30 plus years and overturn the penalty phase is extremely unusual. In fact, I had not heard of it until the cases in Nevada that have come up.
I want to talk a little bit about, as you know, the issue here on appeal. The Ninth Circuit deemed this language, the jury instruction language, given to be too vague, and that was for depravity of mind instruction. Now, as some of our viewers may not know, but you and I certainly know, jury instructions are a huge part of a criminal trial, and I've written countless motions arguing about what the wording is going to be on jury instructions. Any good defense attorney is not going to just hand over the pattern instructions for the state. You're going to want to fight on every last word. Can you give us an insight into what you, from a defense standpoint, what you might want to try to get in terms of jury instructions and just how important that is?
Right. And so first of all, just so everybody understands, jury instructions is basically the law that the judge gives the jury to determine the case. It's the definition to the law, the elements of the law. In any trial that you have of any merit, of any consequence, there's always discussion about the type of language that would be used in jury instructions. And in California, most of our jury instructions have been debated in the appellate courts for years.
Right.
And some courts have taken different approaches to different instructions, and the Supreme Court hasn't ruled on it, so there's some debate and there's some room to wiggle. And anytime you're defending anybody, depending on the charge, you're looking at how various courts have determined what instructions to go to a jury on that charge. And depending on what side of the aisle you sat on, when you're sitting on the prosecution side, which I sat on for 10 years, or the defense side, which I've now sat on for 16 years, you look for the instruction that would best favor the argument you're trying to make to a jury. And then the judge finally decides. Now, the thing about it is that what's unusual is that my guess is that the instruction that was given in '88 was an instruction that the Nevada courts have given in whatever death penalty cases they've had for the last, 31 years. And so if that instruction was deemed vague in that case, my guess there's a slew of cases that they've given it in that also then would be ripe for appeal.
You're absolutely right, Ron, and that is an issue. This is just one of several cases coming up that that jury instruction was given, and we know of specific cases that it's also going to apply to too. This is just the beginning of these second round sentencing phase trials. So it is an interesting point.
So it's going to be a huge mess for prosecutors in every county of Nevada.
So it's so interesting that you've sat on both sides of the aisle. Talk a little bit about, in general, sort of the perceptions surrounding issues in the criminal justice system with the death penalty. Yesterday, we talked a little bit about, from a societal standpoint, a lot of people go to moral arguments. However, I think those of us sort of in the practice often talk about the economic consequences that go along with trying death penalty cases. What's your experience there?
Well, I mean, it depends who you're talking to. If you're talking to a jury about whether or not to impose the most serious penalty the law allows, they don't care about economic consequences. I mean, they really don't. Nobody cares. If they think a guy needs killing and a jury is inclined to do it, they're not going to worry about the financial aspects of it. Very few people do. I think what more people are concerned about is the type of the crime, how heinous the crime was, and also who the person is. And typically the people who face the death penalty are people who in the process. See, what most people understand is the death penalty is not you don't determine it by statute. It's really at the discretion of the district attorney or the head prosecutor or whatever county the case is being tried in. He decides or she decides whether or not to impose the death penalty. And so anytime you're letting people decide whether or not they want to impose the death penalty, obviously there's a lot of discretion in there. And for instance, a prosecutor in Northern California could think much differently than somebody in Central California does, than somebody in Southern California does. And in our state, in California, that's exactly what happens. In San Francisco, they don't impose the death penalty. Their prosecutor has made it clear that they don't want to impose the death penalty. In the central part of our state, like Bakersfield or the farming communities, they do. And where I live, Ventura County, they still say they will. They haven't in a while, but they still say they will. And in Los Angeles, they have shown that they do not want to do that anymore. And so basically where you commit your murder now, your death penalty offense determines whether or not you can get it in a large part. So the decision-making process and whether or not to impose the death penalty, most prosecuting offices have a procedure. The one I was part of, we had senior prosecutors all weigh in and present their opinions to the DA. We'd call a panel of prosecutors, which I sat on about 15 to 16 times, where we all sat in a room. The prosecutor assigned to the case would write memos, and the investigator assigned to the case from the DA's office would do a complete background on the defendant. And we would all decide, after reading all that, or at least express our opinions, whether or not somebody should get the death penalty. And those rooms are typically divided. I was a prosecutor who wasn't particularly pleased with the death penalty. I thought it should be done in only the most extreme circumstances. In the era that I worked in the DA's office, frankly, it was given quite a bit. We sought it quite a bit. There are other people who are much more aggressive with it. There are people that, depending on if you're a man or a woman, treat you different. And then there's a lot of bias in terms of, I believe, in terms of the way we view the person's place in society, and that sometimes can come down to economic status. You see very few rich white males who commit death penalty offense get the death penalty.
Absolutely, and that's a huge criticism in the criminal justice system at large, and also for, in the federal system, we something that we strive for is obviously consistency in sentencing. So when you're talking about it matters the geographic location where you commit the crime, whether or not your chances of being committed to the death penalty, then that raises some serious questions. I want to talk about, you mentioned that your personal belief, and it's actually not just your personal belief, but the legislature and the Supreme Court has said actually that the death penalty obviously is reserved for only the most extreme cases. Now, the issue that we're running into here with the Valerio trial is, how does a jury discern exactly what the most extreme cases are? And according to the Ninth Circuit, under the Eighth Amendment, a jury instruction needs to be sufficient enough to channel the jury's discretion into some subset. So there needs to be sort of a recognizable way that you channel into these categories. Can you talk a little bit about those specific aggravating factors?
Yes, and in California, it is codified in terms of what the jury can consider. And there are what we call aggravating factors and mitigating factors that a jury can consider in determining their decision on whether or not to impose the death penalty. And in California, we have an instruction that leaves it completely to the jury's discretion. Matter of fact, there's an instruction, and I'm paraphrasing, that says, for any reason, if you feel you do not want to impose the death penalty, that is sufficient cause not to do so. But so, like aggravating factors, the most common ones would be prior convictions. Does a person have a long history? I say guy because 99% of the time it's a guy. Does a person have prior convictions of violence? Uncharged crimes that can be proven. Many times you see there's a lot of uncharged sex offenses that you can prove to a jury in the penalty phase. His behavior in custody can be aggravating, or mitigating, depending on how he's doing. He could be a model prisoner, or he could have. Usually, by the way, death penalty cases, you don't seek it on a first-time offender. It's just trying to think if I can remember one. I really don't remember one in my experience where it was a first-time offender who killed somebody, except for. I'm sorry, I take it back. One time when people were having an affair and they killed the guy's wife. That's the only time I can think of when it was a one-time offender type deal. But usually when they seek the death penalty, it's based on people with lengthy criminal histories, which end up being the most aggravating factors to most people. They see a person with a long rap sheet of violence, that he's done nothing productive in his life, that he's been in and out of prison or jail, and that jurors weigh that heavily. They also look at the crime itself. The crime itself can be an aggravating factor. There are certain crimes that are just more heinous than other crimes. It's much different if you have a rape murder than if you just have a murder. It's much different if you kill a child than if you kill an adult. People think it's more aggravating to kill a child. Then there's mitigating factors. Mitigating factors can be mental defect. There's some mental illness the person had. It can be upbringing, basically never having a chance to live a life that most people would think is normal. It can be things such as that they've done other good deeds in their life and have been productive in other areas of their life, that they show some redeeming characteristic. And the jury is supposed to assess all this out and determine whether or not the person is justified for the death penalty. In California, we allow the victims of crime, the family members, the survivors, to make statements to the jury about the loss that they have suffered in the penalty phase.
Right.
And that's really powerful evidence.
Absolutely.
To hear a mother talk about losing a daughter and how it's affected their life and ruined their life is very powerful evidence when people are seeking the death penalty. And we allow the defendant to put on any evidence he has from his family or friends, talk about his redeeming characteristics.
I'm interested that you noted that you said there are some crimes that are just inherently aggravated in and of themselves, because I think we're having an issue with that in this trial. Yesterday, we heard the lawyers sort of bat around the jury instructions outside of the presence of the jury, saying that the torture, mutilation, or other serious depraved physical abuse needed to go beyond the killing. So the issue is, we're unclear, obviously, exactly what transpired, but we know that this woman was stabbed over 40 times. But the question is, are there aggravating circumstances beyond that? Now, that doesn't really make sense to a lot of people, because you would think that just in and of itself, inherently, that is a crime of torture, of mutilation, that in and of itself, there shouldn't need to be anything more. But are we thinking about that in the wrong way? Can you speak to that?
Well, yeah, I can actually. I'll give you an example. When we would debate death penalty when I was in the prosecutor's office, one of the first questions we would ask is the victim a taxpayer? Okay, and it sounds harsh, but the reality is, if you are going to go and kidnap a woman who has a family and is working a job and parks at the Barnes and Noble to get a book, and while she's going to her car, she's shot in the head and her car stolen, that's more aggravating than if you are shooting a gang member. It just is. I mean, you can argue it, the life is equal and they both have a value and their life should be deemed equal. Yeah, maybe in a theoretical sense they are, but in the reality sense, they're not. Mm-hmm. When you shoot somebody who is considered to be a bad person, if the victim is not a reputable person, it's much different than when you shoot somebody who is a contributing member of your society. And frankly, it's much different if you kidnap a 5-year-old girl off the street and kill her than if you go walk up and you're robbing somebody and in the robbery somebody gets killed and it's an adult. Just think of your reaction to both crimes.
Right.
You know, both are unfortunate, but there's certain passions that are engendered when a child is killed that you don't have. If it's during a sex assault, if somebody breaks into your house and assaults a woman and kills her, that's a much different crime than if somebody shoots somebody in a park in a squabble. It just is.
Right.
And they're aggravating type crimes. It's different type crimes. So that's what they're speaking of. There's certain crimes that are just depraved, that when you read about them, you just can't understand how humans can be subject other humans to such cruelty.
Right.
You just can't. And I mean, I was involved in a torture case that they thought of things to do to the victim that just were beyond comprehension. Like, who even could comprehend doing these things? You know, like, who would think this way? And the only thing that you could think is somebody who's incredibly sick and depraved could do it.
Right. You know, we talk about another thing people talk about is retribution, like you said. But you also touched upon the fact that, you know, you've seen both sides. You've obviously worked on the prosecution side, but also on the defense side. You've probably gotten to know some of these defendants and their family. Can you talk a little bit about the emotional toll this may take on a family in general, or anything, any glimpse into sort of the emotional aspect?
Well, I mean, I can actually, but what's interesting, at least in my experience, is that the family that I knew the best was a family of a gentleman I was prosecuting at the time, and he was eligible for the death penalty. And he was a skinhead gang member who had done all kinds of stuff in our town, and then had been part of a murder of a 14-year-old girl in a bathtub at a sleazy motel. Awful, awful crime. And you would think somebody like that would be without redemption, that there would be no way you could see anything positive in the person. He had a family who was actually very normal, was obviously against the lifestyle their son had decided to live. And he also had a fiancée who, you know, saw a different side of him. And in investigating the case and, and chasing this gentleman in terms of trying to catch him for this crime, I got to know all those people in his family and speak to them at length, and so did my investigator. And what we found was that he did have redeeming characteristics, that the family really struggled with their son's choices in life, and that there was some redemption to him because he had a family that still cared about him and he still cared about them. I mean, when somebody can at least show that they can care about other people, that they have concern and empathy for other people, that's something you take seriously when you're deciding whether or not you're going to recommend for a jury to take this guy's life. In addition to that, what he ended up doing that persuaded me was that he gave us information about law enforcement people that were in danger from the same gang, and told us who was planning on hurting these people when he was still didn't know what his fate was going to be. And he did it out of concern for some of these people who literally were the ones investigating him and attempting to convict him of this murder. So you do get a sense for these people and the struggle they have and how painful it is for them.
So what did you do in that case?
I recommended no death penalty. And I said I would not prosecute him for the death penalty. And the DA had a different opinion. And so I said, you have to find somebody else to prosecute the case. It was one of the reasons I left the DA's office at the time, was that difference of opinion, because I could not understand how we could seek the death penalty on somebody who had tried to literally, in his mind, save people's life at risk to himself. Because when you're in custody and you help the police, the other inmates don't take that well. They don't appreciate that. So there are, and what I have found doing this work that I'm doing now, defense work, no matter what the case, there are redeeming characteristics in most people. I did when I first started doing defense work, I had to take an appointment on a gang murder case that could have been eligible for the death penalty, but ended up the DA decided not to seek it. And the guy I represented was, by all accounts, probably didn't lead the best of lives and was probably responsible for a lot more pain in our community than than anybody. I mean, he was a serious guy in terms of his career path, and his career path was a life of crime. And what was interesting in that case is that the evidence of the case was overwhelming, and it was a really difficult case. But during the case, my father had a massive heart attack, and I had to leave in the middle of the trial. The trial had to get suspended. And I was gone for about 3 weeks. And when I came back, he had wrote this heartfelt note to me, telling me not to worry about his case, that he was doomed anyway, just take care of my family, and that I had done a great job, and he'll never hold it against me, and always respect me for what I did, and thinks that I did the right thing by going to my dad and being with him when he was ill. And I just thought, wow, I would never expected a guy like this to write this type of note.
Right, right.
And,
do you ever see, I'm interested, I've been interested in the death penalty for years, and I follow the work of Sister Helen Prejean. I don't know if you've heard of her. She's a vociferous advocate of doing away with the death penalty. And one of her big platforms is that oftentimes the victim's family doesn't really feel any resolution or closure, shall we say, upon the death penalty being instituted against the perpetrator of the crime against the family member. Have you seen that to be the case, or is it usually, are the victim's family members usually fighting pretty hard for the implementation of that most serious punishment?
The victim's family wants answers, in my experience. They want to know how their loved one died. They want to know, they want the case solved, and they want the person prosecuted. I know in the cases I've been involved in, once the guilt phase was over and the person was convicted, there was relief.
Right.
They did participate in the penalty phases. There was no doubt about that, but I don't think they cared. I still don't think they care. And I can tell you, none of those people they're on death row, but none of them have been killed.
Right. Well, that's another issue.
I don't expect them to be killed either. There's a guy that I convicted in 2002 who still sends me notes.
Right.
So
that's another issue. The bureaucratic, the red tape and the oftentimes sort of glacial pace of death penalty litigation is certainly an issue to take into account.
That's not the litigation, actually. I don't think that's the issue. Like in Texas, they've proven you can kill people pretty quickly.
Right.
In Georgia, they've proven you can kill people pretty quickly. What I think is that in California, every time it's come up, our state has voted to keep the death penalty, but we don't have the stomach to impose it.
Right.
We just don't. I always said, if you guys want to have the death penalty, then I'm against the death penalty. But if you want to have it, you should use it. And if you're not using it, what's the point of it?
Right.
Just have it. Does it make you feel better? I mean, it's a lie we tell society that we in California have the death penalty. We haven't killed anybody since 84, 85.
Wow.
And I don't think anybody is. And right now there's a moratorium.
Right.
We still have death rows, and the inmates know they're not going anywhere. So what's the point?
Right. I want to get into some of the trial testimony, Ron, and we were speaking about redemption, and I think this will be a good lead into, guys, to JV-22, because the defense wanted to put on a minister, actually, who befriended the defendant in this case after the fact in jail. She wrote to him. Can you hear me?
Yes.
She was a member of a parish that apparently was anti-death penalty. And one of the issues that the prosecution was fighting over was whether or not they were allowed to sort of probe her biases and whether or not she in fact initiated this contact with the defendant because she is anti-death penalty. So I want to take you guys to the hearing outside the presence of the jury regarding when this woman is going to take the stand and what exactly the defense and the prosecutors can ask her about, and then I want to talk to you about it after.
Okay.
Thanks, guys.
Is a capital punishment abolitionist who began her relationship because Mr. Valerio was on death row. And they said they're going to bring her in here to talk about how they're friends. Apparently, she's friends with a lot of people who are on death row, and certainly her bias is going to be highly relevant to cross-examination. It's something that Lovato says we're entitled to get into. And so I just want some direction from the court, considering the court's ruling saying, don't go near this unless you bring it to my attention. If I'm mistaken, and this is a different case, Stevens, and our research has shown, but I believe based upon just even what Mr. Pitaro says, that this is the same individual.
All right, so where are you wanting to go?
We'll cross-run our bias.
Okay, well, yeah, I don't necessarily, I mean, I guess, why don't you give me just a thumbnail as what you're planning on doing, and that way I know I'll turn to them and say, what issues do you have with what Mr. Pitaro?
Well, the part that most concerns me is the reason she started the relationship with Mr. Valerio. How is it that you identified Mr. Valerio as a person to have this type of relationship with? Well, because he was one of the people on death row. And I'm unclear right now whether or not she found him from the websites that are out there for death row inmates to find abolitionists. But my main concern is that whichever way I think of this in my mind of going about, you know, you're an abolitionist, you don't believe in this, you reached out, you started the relationship with Mr. Valerio, and how is it you found Mr. Valerio? The answer every time leads me back to I can't think of a way to get there where I get to bring out that this is a manufactured relationship, manufactured around the fact that he's a death row inmate. I don't know how it is I can bring out that situation and her biases in coming in here to say, oh, he's a lovely individual. Yeah, you think about that about every murderer that's on death row. And I don't know, everywhere I turn I get to the point where it's going to come out.
The issue is referencing to death row.
Correct, that's the issue for me, is that the court told me not to go there. We were able to limit it for Hatcher, we were able there to limit it, but I just don't know how the answer is going to come out. Unless I'm wrong and there's some other reason that they have this relationship, but based upon my research, it's my belief that their relationship started because Mr. Valerio was on death row and that she routinely
Can we say that he was that she has this relationship with people who are death penalty eligible?
Well, why can't you just say, like, the anomaly these things are, is that she's involved in, you don't have to use the word prison ministry, but,
you know, being a death row abolitionist is
I don't know what
different than
death row
prison
abolitionist is what? I mean, how does that reflect?
I mean, anti-death penalty, I mean, someone who goes to the nth degree to try to defeat the death penalty for anyone.
Well,
I'm not saying that that's bad or wrong,
No,
but I mean, it goes
being
to her perspective.
No,
in
being
terms
a
of her
pen
relationship.
pal and what she's going to testify to, any more than a juror who is opposed to it. I mean, I just don't see how the fact that someone is opposed to the death penalty goes to the fact she's going to testify the relationships she had with him through being.
If she has relationships with 20 or 30 death row people, and she does this in an effort to enhance their chances of escaping death row, that definitely goes to her bias.
Well, I don't think there is, Tom knows, he's the one that has dealt with it, but to say that she's going to come in here, she's an ordained Presbyterian minister, she's going to come in here and she's going to commit perjury in this court so she can try to get someone off death.
Well, wait. You know, you know,
But that's
they're entitled to attack her bias, and just because she is a Presbyterian minister doesn't mean that she doesn't have biases. I'm not suggesting she's going to lie, but she has biases that may color her testimony and her perceptions. You know, so I mean, you know, just because she's a Presbyterian minister, it doesn't have any real. Those are all points that you can bring out in terms of enhancing her credibility or minimizing her bias, but it still goes to bias, and it's still relevant. Bias is bias. And if she hates the death penalty and goes around the country befriending death row inmates in order to attempt to figure out ways to keep them off death row,
Well, is that possible?
I'm not saying that it's not a redeeming quality. I'm saying, though, it definitely goes to her bias.
No, but it's the last part that is the jump.
Well, I don't know. I mean, you know, if I don't know why she does this. She's showing up at a bunch of different trials of people. I mean, I don't know when she befriends it. If she befriends people who are, you know, getting a shot at retrial, or, you know, if she participates in petitions to the court, you know, asking for lien. I mean, again, I'm not saying any of this is not redeeming or valuable depending upon your perspective. There's a lot of perspectives on it, but it definitely goes to bias. And I just don't know what we're talking about. Mr. Erickson, can you give me a sense?
Your Honor, I have had a number of conversations with her. I've met with her in person. This is the first that I've heard of her possibly being involved in multiple death penalty related cases. I do know that she, you know, reached out. I believe that she reached out to Johnny through some type of pen pal organization, and has maintained a relationship with him for, I think, going on 10 years.
Since 2009.
Yeah, and that she's been out here, I think, 4 times, paid her own money to come out and visit him, and things of that nature. I will be meeting with her tonight, and I certainly will be looking into this issue. I don't know if the state has information that she has been involved in testified in other cases in Nevada. I don't have that information.
I'm hoping to get some transcripts without telling them what the cross-examination is going to be, but it's even farther than that. Let's just say you are somebody who reaches out to capital defendants, and then you befriend them. Are you someone who is more likely to find a redeeming quality than somebody who is horrified by the actions of this person and would never befriend them? She affirmatively takes it upon herself to locate capital defendants and befriends them, and then she's going to come to a courtroom and say redeeming qualities about that particular individual. I am allowed to cross-examine on it isn't like
I'm not debating that issue. I agree with you completely. The issue is how, and I tend to, at this point in time, you know, say that she has an interest in, you know, helping those individuals who are death penalty eligible, rather than saying that, because at the time,
and that's fine. In 09, that's true.
You
In
know,
09, he's not a capital defendant.
Yeah, he's not a capital defendant, so he's death penalty. I mean, that's not going to shock the jury. Obviously, he's death penalty eligible because we're sitting here for the last 2 weeks doing a death penalty trial. So, I mean, I'm leaning toward, you know, you discussing with her and making sure she doesn't go to death row inmates. And I'm leaning toward, you know, making you all refer to him as death penalty eligible, and that she has an interest in that. I mean, you may ask her, don't you have an interest in helping those people who are death penalty eligible? And she says, no, this is the first guy I've ever, you know, befriended. You know, well, that we aren't, you know, you can ask, did you befriend him because he's death penalty eligible? I mean, she says, no, I mean, I sort of piqued my interest, but because he's a great guy. I don't know what she's going to say. You know, to the degree, Mr. Erickson, you think there may be any issue, we can, you know, try to do something outside the presence of the jury. But I'm leaning towards saying, you know, letting the state say, you know, is any of your interest in him because he was death penalty eligible?
That's fine. I mean, that would solve the problem, although was maybe the first guy she joined that was death penalty eligible. Certainly the court's not ruling out, there wasn't a suggestion here that if she were to deny my question, I couldn't prove this up through extrinsic evidence since it goes directly to the
Yeah, I mean,
bias.
you can obviously prove bias through extrinsic evidence, but I mean, let's wait until we have that issue. Be sure you've got the right, I don't know, whatever, I forget.
There's not that many of them. I believe I do. Certainly, if there's any reason for me to doubt there is, and I won't ask her the question, but I can't imagine that this happened any other way.
All
We're
right.
reaching out to Mr. Valerio.
I've seen a lot of bizarre things in my life, so I'll just leave it at that. But no, I'm leaning at this point in time. I think it is relevant to bias. I'm not suggesting that indicates she's going to lie in any way or commit perjury, but it's, relevant to how she may perceive or how she, may describe certain aspects of her relationship with the defendant. And so I'm at this point, saying, let's have it, to the degree that she talks about it's relevant, or she talks about her interest in those people who are on death row. Let's just leave it as those people who are death penalty eligible. I mean, even those people who are on death row are just death penalty eligible. They haven't.
Welcome back to the Law News Network. I'm your host, Caroline Polisi, for the morning, and we're catching you up to speed on some prior testimony in Nevada versus John Valerio case. That is a retrial of the sentencing portion of this Nevada man's murder case. Now remember, he remains guilty under Nevada law of the 31-year-old conviction for killing a Nevada prostitute. Now we're joined today, a fabulous guest, with Ron Bamieh. He's a former prosecutor and criminal defense attorney. And Ron and I were just talking about sort of strategizing about, in the penalty phase, what a defense attorney's strategy may be. And before we went to the break, we said we were going to throw to this back and forth between the prosecution and the defense. They're fighting about whether or not this woman, she's actually a minister who befriended Mr. Valerio after he was convicted in prison. And they really had this sort of pen pal-like relationship over the years. And the prosecution says, look, she is way too biased to get up on that stand. She is an anti-death penalty crusader. We shouldn't put her on the stand. It's way too biased. And the defense is saying, Your Honor, that may be the case. However, she had a real relationship with the defendant, and therefore she should have a right to take the stand. Ron, do you have a feeling about the issue?
Yeah, I mean, listening, I was watching the arguments in the clip there, or on the feed, whatever that was. There's no doubt she'll testify. There's no doubt that she'll get to testify. And the general principle for most judges in death penalty cases is that the defendant has anything positive, we put it in, and it's allowed in. And so there's no doubt she's going to testify.
Right. And
no
she actually has testified. For our viewers, this was previously recorded, and she actually was allowed to testify, and we'll show you some clips of that. But you're absolutely right. I would think, Ron, that if there's any question about it, especially in the punishment phase of a death penalty case, you would give the benefit of the doubt, as it were, to the defendant.
Yeah, most defendants will struggle to find witnesses who will say nice things about them at that phase of the trial. There's just not a lot of people who are raising their hands saying, let me talk about all the good deeds the killer has done in his life. Nobody, usually at that page, people are distancing themselves from the defendant. And you get very few people that are not family members who will come forward and say something positive about the defendant. So this minister, who it seems that was part of her ministry, was to help people on death row and talk to them. It appears, even though she may have some biases, that she'd be at least somebody who, with some credibility, who could come testify that, look, I see redeeming qualities in this guy.
Right. And so as a defense attorney, what do you do in that type of situation when you're thinking about who are we going to put on the stand? Is it very important to get people that aren't family members to testify to the whatever good character there may be in this defendant?
Well, the reality is that you go, okay, who will say anything? And you don't really care about resumes at that point. And you try to find who would say something positive about this guy. I mean, you'll take his kindergarten teacher if you can find her. You'll take a neighbor who thought he mowed a lawn once and was nice. You'll take whatever you can get. I mean, it's not like there are a bunch of people lining up saying, oh, pick me. I'd love to testify about how great this guy who raped and killed this person was and stabbed him 45 times and threw him in the trunk was. Let me tell you what a great guy he was. You don't find those people. So you search high and low for anybody, and you're telling your investigator, go talk to everybody that you can find will say anything about this guy that is positive. And you're not very picky. Now, it's great if they don't have the same last name as your guy, and it's great if they're not the grandma. That's a bonus. But if that's all you got, that's what you put on, because you're trying literally to save this guy's life, and you're not going to leave any bullets in the gun. You're going to put on anybody and everybody you can who will say anything redeeming about the person whose life you're trying to save.
And on the flip side, Ron, I know you've prosecuted these cases as well. As a prosecutor, do you put on character witnesses in the punishment phase of a death penalty case for aggravating factors?
Yes, you'll put on every victim that you can of the defendant to show how his crimes, whatever they were in the past, have affected them. You'll look at how he behaved in custody. In the cases I did, the people behaved very poorly in custody, trying to kill witnesses and doing things like that, to put that evidence on to show that, you know, even in custody, he's a really dangerous person. You'll talk to the victim's family and talk about the person who suffered the greatest loss. And you'll make a determination in terms of how many of them you want to call for the greatest impact. And I'll tell you, it's very moving testimony when family members get up there and talk about the loss of their loved one.
Absolutely. I think most recently we saw in the Michelle Carter case, we heard some very powerful testimony from the family members of Conrad Roy, and that was very moving. So here the jury is going to get to decide, there's three possibilities to impose upon Mr. Valerio, either life with the possibility of parole after 20 years, and of course we know he's already served more than 20 years, so this man potentially could be eligible for parole almost immediately. The other option is life without parole, and then the final, obviously, is the death penalty. If you're the defense attorney here, what's your strategy for what you're recommending? Are you going straight for life with the possibility of parole, or do you kind of temper that with life with parole?
Well, first of all, you talk to your client, and
yeah.
You know, if I'm the client, I'm like, life without parole or the death penalty are pretty much equal to me. So let's see if we can get me out. That's what I'd be if I was the client. I wouldn't be like, yeah, I'd be good with, you know, staying here for the rest of my life. You know, they all want out.
Right.
So you would try to see if you can fashion a credible argument that would get you life with parole. His problem is going to be that he's already exceeded that time. And when jurors hear this crime, and they're going to be, I'm sure they were allowed to put in the details of the crime and what he actually did to this woman, it's hard for them to justify letting the guy out. I mean, I would find it very hard to believe that a jury would hear a guy who stabbed a woman 45 times, threw in the back of a trunk, like the way he did, is going to say, hey, let's let this guy out now.
Right.
I'm good with that.
It's an interesting wrinkle here in a death penalty case. Usually, you know, when juries are voting whether to convict or acquit, the instruction always is not to think about the penalty which may follow from a conviction, and merely to follow the elements of the offense to make sure whether or not each of those elements are met, and not to think about really the consequences. But here it's the exact opposite. It's really the jury who has this man's life in their hands. I want to talk a little bit more about talking about how defendants behave in custody. The next clip we're going to show is from the prison warden that oversaw John Valerio in prison. And I think you and I both probably know that dealing with the BOP as defense attorneys when your client is in jail sometimes is difficult because oftentimes you get a different story from what happened from the defendant's point of view. It's not really a legal processy that you can employ. I mean, there are ways to sort of challenge demerits that one receives, but it's kind of a difficult middle ground for a lawyer to be in. Can you talk a little bit about how you sort of navigate those waters between your clients and the Bureau of Prisons or whatever body it is that implements those?
In our county, it's the sheriff,
Okay.
and the reality is that there's no due process at that point. It's
Yep.
just, there's none, and they make an allegation, and they'll go into the cell and they'll say, "Oh, you're hoarding blankets, or you're hoarding pills," or there'll be a fight in the jail that he'll be involved in, and they have a tough responsibility. They got to house and take care of and keep safe all these people who are not exactly the best rule followers in our society. So they get more than the benefit of the doubt. There's really nothing you can do but time to placate the authorities for them. I mean, we have a hard time getting medical care for our clients when they have medical issues dealing with the jail doctors, because in a lot of facilities, and I'm not saying they're being treated inhumanely, but it's a mass production business, and I always tell everybody, the jail or the prison is not a service industry. Don't expect chocolates on your pillow. It's a rough place to stay, no matter what it is. And I know sometimes in society we have this feeling that oh, they're in jail, they're getting 3 hots and a cot, it's better than they could get anywhere else. I can tell you, there's no jail that any normal person on this planet wants to be in. It's just not a good lifestyle.
Yeah, I can affirm, I can agree with you on that. I often have the same thought. There's no such thing as sort of these camps that people say white collar defendants are sent to. Jail is not a good place to be. And I agree with you. There is no, oftentimes defendants don't necessarily understand that there really is no due process right once you're in the custody of the prison officials, and that the judge no longer really has control over. I mean, to some extent, a judge can recommend to the Bureau what to do, but it's very difficult. And as you said, the benefit of the doubt is given to those wardens. Ron, I want to thank you for being here with us today. We're going to go to a clip now that will probably take us to the end of our hour. We're going to see JV 25, that's Sherman Hatcher. Again, that's the retired warden. But I want to thank you for your insights with us today. We hope you'll come back to join us, and have a great day.
Oh, you too. Thank you for having me. I really appreciate it.